Court case involving Wolf v. Colorado. It took place in 1949, and it led the way to similar debates in further history. So a Colorado woman named Gertrude Martin was hospitalized for complications of an abortion, and she told the doctors who were treating on her that the doctor who performed the abortion was Dr. Julius A. Wolf. The abortion that was performed was considered a back alley abortion, and that's because it's illegal, and it's and he kept it off record so no one would know, which is illegal in the state of Colorado. And so police decided to keep an eye on Wolf, and one day they raided his practice and took all the lists of his patients without Wolf knowing. Wolf was then arrested by police and charged with performing illegal abortions. At the district courts, he argued that it was a legal search and seizure, which is against the Fourth Amendment. But they still found him guilty. However, he decided to appeal, and he went to the Colorado Supreme Court, which also found him guilty. And the Supreme Court of Colorado believed that if evidence was illegally obtained, it was still admissible in Colorado courts. So he appealed the Colorado Supreme Court, and so the Supreme Court decided to hear the case because it was kind of a controversial issue during that time. So Wolf's main argument was that the police used evidence that was legally obtained, which is against the Fourth Amendment. And the question was, can legally obtained evidence be used in court? So this was taken to the Supreme Court in 1949 with Chief Justice Fred M. Vinson, and other justices that accompanied him was Justice Fred Frankenfurter, Justice Hugo Black, and Justice William Douglas. So the main argument that was going on in the court was, should states follow the Fourth and 14th Amendment concerning illegal evidence, and if evidence should be used. It was also if the exclusionary rule was to also be applied to the states, like the federal government. So Wolf's argument in the courts was he was illegally searched for illegal search and seizure under the Fourth Amendment, and therefore the stuff that they found in his office should not be used in the courtroom against him because of the protections of the 14th Amendment and the Due Process Clause. So Colorado argued that the 14th Amendment had no effect on the use of illegal evidence, even if it violates the Fourth Amendment. And kind of like the question that everyone was thinking is should it be used against him for trial because of due process for legal evidence? So Justice Felix Frankenfurter agreed with that the Fourth Amendment was applicable to the states through the 14th Amendment. But however, the 14th Amendment does not impose limitations on states, and the due process of the 14th Amendment does not support the Bill of Rights. And and Justice Hugo Black had a concurring opinion to go along with this. The dissenting opinion was from Justice William M. Douglas and Justice Frank Murphy. Justice William Douglas argued that the exclusionary rule must be used to enforce the Fourth Amendment rights properly in all the states. So this is Justice Douglas right here. This is Justice Chief Justice Frank Vinson, and this is Justice Frankenfurter. I like that name. Justice Frankfurter expressed the majority opinion in favor of Colorado in a 6-3 vote, and they held that the Due Process Clause encompasses most of the Fourth Amendment, but not full protection from the illegal searches. And the 14th Amendment does not require evidence illegally obtained in violation of the Fourth Amendment to be excluded. And evidence is admissible as long as there is a fair trial. So this is the first time that the Fourth Amendment rights were incorporated by the 14th Amendment and applied to the states. And this was further brought up in 1961 in Mapp v. Ohio, where they discussed the same topic, except this time they ruled that they had to apply the exclusionary rule on the evidence. And so here's kind of like a cartoon showing how the states are not kind of contained with the Bill of Rights, but then with the 14th Amendment to go along with it, state governments are also kind of restricted. And you something about the exclusionary rule that I found. From the Wolf vs. Colorado and Mapp vs. Ohio courts, courts today are not allowed, do not use illegally obtained evidence because it's against the 4th and 14th Amendment, and they use it through the exclusionary. They don't use it because of the exclusionary rule, and now just like courts are protected by the 4th and 14th Amendment working together in the institutions.